I couldn't practice in any other language, even though my Afrikaans is sufficient to examine witnesses. And I do that because in the old days, if we exercised our right to speak to them in English, the judicial officer said, well, the witness was confused because counsel insisted on speaking English to them, which was not their mother tongue. But it has served me well in my profession for over 45 years.
I think that people are intimidated by the law, even people who are relatively sophisticated in inverted commas, people who are less literate, who are intimidated both by the language and by the bureaucracy that surrounds the legal process. It becomes even more difficult.
Well, I'm afraid that I can't carry on in your own language other than greet you now, but I have my tongue and my ears, timber, here. The court system would be at an absolute standstill if it were not for interpreters. In relation to the African languages, the interpreters in the early 50s, when I started practicing, came from a farming background where they had contact with the African people. They seemed to manage reasonably well. But in those early days, the transactions which came before the courts, particularly criminal matters, were not very complicated, and they were not involved with abstract ideas.
Sawubona, good morning. I'm Patrick Pringle. I remember sitting through many court cases and seeing miscarriages of justice taking place, specifically through the misinterpretation of what people were saying. I did speak and do speak a bit of Xhosa and was able to follow those proceedings. The specific example was of a woman who was an accused in a case. During the course of this trial, this lady was exercising the Thonipa custom, and she was avoiding the use of the first syllables of her husband and possibly of her father-in-law's name. And she came across as being very evasive. I understood what was happening. I could see that the interpreter understood what was happening. But clearly the magistrate had no understanding of that situation. And one was trapped in the situation where not even the interpreter could explain to the magistrate what was actually behind this. So when it came to making a judgment in the matter, the magistrate had no difficulty in finding her to be a completely evasive witness who wouldn't answer the questions directly, when all she was doing was actually complying with her custom. Since
1994, when African legally trained persons have been appointed to the bench as magistrates or judges, they're in a position of understanding the witnesses in the primary language spoken by them. They, of course, have a much more clear appreciation of the issues involved. And it may well be that the nuances in the question and answer may be lost by a mediocre or not such a good interpreter which they pick up.